We are now recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much, Madam Clerk. First order of business is to call this case, which is number 2023-0991, Edward Wright versus Thomas Turkle III, the Commissioner of Massachusetts Department of Correction and others. I'm going to introduce the panel. I'm joined today by Justice Eric Nyman and Justice Andrew D'Angelo. My name is Ariane Buno. Mr. Wright, when we begin the argument, you're going to be going first, and you're going to have 15 minutes to present your argument to us. I want to tell you that we've read your brief, we've read the record carefully, and we may intervene upon occasion and ask you some questions. When we do that, we do not mean to be rude. It's just that we have some parts of the record we might want to clear up, etc. All right? Good morning to you too, Attorney General Handler. I know that you know the rules of the court, and you know that you, of course, will be going second. And you also can be assured that we know the record quite well and get to your points as soon as you would like to when it's your turn to give us your argument, okay?
Yes, I actually am not an attorney general. I work as counsel, associate general counsel for the Department of Corrections, a special attorney general.
Thank you. Okay. Thank you for that correction. I appreciate it. All right. Mr. Wright, there's going to be a timer that's going to go on your screen. You should be able to see it. And as I said, it gives you 15 minutes. It'll tickle down as we go. All right. We can start right now.
Good morning, Your Honors. First of all, with this case, is there any particular area you would like me to cover, or would you like me to go where I'm going?
You go where you're going. Let's start out with hearing from you.
First, I'll deal with exaggerated. It's an exaggerated response is that summary judgment shouldn't have been granted based upon that there is a conflict of dispute about whether it's an exaggerated response. If you've read the on the briefs with the information given from the Department of Correction, that which they did turn over, if you'll see that the number that they placed for drugs introductions to the mail isn't the way that they conflate it, they aggregate it to make it appear more than it is. If you break it down to the drugs that came into the institution, they're basically at a nil rate. And in one course for Susan Baranowski, where I was at the time, for 2016, 2017, they claimed there was 130 introductions or attempted introductions. They do not make any distinction between what was attempted introductions, what was introductions, what were possessions, what were disciplinary report things. But what you should note is, if you go to their graphs that they produced in 2016, there was 75 introductions. In 2017, there was 55 introductions. They conflated them into 130. Now, if you break that down to by monthly, that's only like 7 point something, which they claim is attempted or introductions.
I'm going to interrupt you just for 1 second. Can I interrupt you for 1 second? What I'm understanding, what I'm hearing you say is that you don't think that there was an appropriate basis for this regulation in the first place. Is that fair to say?
Yes, for the blanket seizure, for the blanket seizure and the photocopying of all mail. You're talking, and where this originated at in Shirley Medium, it was even less than that. It was 35 for Shirley Medium, which is to show you that there was something more to it than what they're claiming. Is in 2016, there were like 23 introductions into Shirley Medium, and in 2017 there was 12, so a total of 37. And this is where this started. This is where it started. And if you read Mr. Turkle's letters, which he did on January 29th, January 31st, it wasn't about the mail. It was about the officers and staff bringing drugs into the institution. So their response to the mail had nothing to do with where they started at and where they originated. Nobody even admits to who produced this regulation, who even thought it up.
Can I ask you, Mr. Wright, do you think that it's at all reasonable to have sort of a multi-pronged approach to the problem of introducing illicit drugs into our correctional facilities?
Yes, but it has to be reasonable and according to what is coming in. If the officers are bringing in the drugs as it appears from what they're saying in their complaints, then why are you going after the mail, everybody across the mail? If there's only during the course of a year, it went from 75 down to 55 once you implemented the new regulation, which was a 2017 regulation, which said that they could photocopy any mail that they suspected of after viewing it, looking at it through touch or whatever, that they could photocopy it. How it goes to a broad photocopying everybody's mail for a couple, because when you take 55, which was 2017, and you break that down into bi-monthly, that's what, 3 pieces of mail per month that might be suspected of, because they're not even saying it's drugs through the mail. They're saying attempts, they're saying disciplinary, they're saying code 99s. It's all lumped together when they're making these numbers up. And that's in their graphs. That's specifically their point that they make, that these things are all lumped together. So they're not even introductions to the mail. Some of them were just possessions inside the prison that they threw together with them. And if you read their, which I believe it's at my appendix at 120, 121, 122, if you look at their graphs, you'll see that's what they say. And then if you go to their 2019 synthetic cannabinoid fourth quarter report, which is on the appendix at 159, they tell you that all of these so-called introductions they're claiming are multiple things, such as illicit drug acts from drug.
So you're basically saying they're double counted. Is that your point?
Well, they're counting them. They're not claiming that they're claiming the drug introductions, but they're not drug introductions. It's like some of them are from the disciplinary reports. For possession, inmates are getting bad urines. They're counting those as introductions, and they're not introductions. They have nothing to do with the mail. They're possessions inside the prison. Now,
Mr. Wright, I'm sorry to interrupt you. Can I ask you a question about qualified immunity?
Yes.
So the defendants argue that they are entitled to qualified immunity, which requires us to consider what clearly established law existed at the time of the alleged violations that you are raising here.
Right.
What are you saying is the clearly established law? Is it the regulation 41.12?
Well, it's not it's regulation is part of it, but it's the First Amendment, the Fourth Amendment, the 14th Amendment. Each of those things, the First Amendment has to do with the, as you notice that the lower court judge gave them summary judgment based on freedom of speech. He didn't take into account my argument to him, which was freedom of expression, which the First Amendment covers equally, freedom of speech and expression. He ruled on one and not the other, even though I brought up the other, which I've raised in my briefs to you. He's never addressed it. He left that alone. And the freedom of expression, as I tried to explain to the courts, in our position as prisoners, some of us have life sentences, some of us ain't going home for 30, 40 years, some of us not going home at all. We have parents, we have family, we have friends who die. They send us letters, handwritten letters to us. And now you're telling me you're going to give me a photocopy of a letter it loses this total value for which it was from, because that's the handwritten letter by that person to you, a personal letter before they die. And that's all you have left of them. And now they're telling you, you can't even have that. We're going to give you a photocopy without any reason to say that you are bringing in drugs or that drug is coming through your mail. They're just taking that away from you. That's a violation of the First Amendment.
Thank you. What is the best case you have that is a little bit more context specific? Because the First Amendment, I mean, I understand your arguments.
Well,
speaking though in very broad, you're painting in very broad strokes.
Okay.
Could you give me the best case you have that says that this is constitutes a violation of the First Amendment or the Mass Declaration of Rights?
Well, as I gave you, inside the case, I gave you the Anderson versus Attorney General, which showed that the written expression recognizes in the Constitution itself as the written Constitution. And I gave you that case. Secondly, I need to get into where you raised 481, the mail regulation. The mail regulation is written to protect our rights. It gives the DOC security measures plus protecting our mail. Now, those regulations specify when our mail can be seized and when it can't. It gives the superintendent authority that if he believes that something's wrong with my mail, that he can tell his officers, put me on mail monitoring for 90 days. They can open my mail up. They can photocopy my mail. They can do whatever they want. If he believes that I'm bringing something to my mail, they're knocking that out, and which that regulation is made to protect our rights. That's the way the regulation is written. It has not only that, but it has the due process clause within that regulation, which states,
I'm sorry to interrupt, but I just want to make sure I understand your argument. When you say by knocking that out, they're knocking that out, are you arguing that the regulation allows for them to review and photocopy the mail in certain circumstances, but they're knocking out the in certain circumstances part and taking all of the mail and reviewing it and photocopying it, so they're not following or abiding by their own reg?
yes, because of
Okay.
41, I think 4112.2. That says to the specific, if the officer bringing the mail in sees the mail by touch, feel, smell, he sees something odd with it, he can take it, pull it to the side, photocopy it, give us the photocopy. If he wants to go test it to determine if there's drugs involved in it, he may do so. They're eliminating that. Their argument has been, well, we put that in there, and so that means we can photocopy everybody's mail all at once with a broad stroke, just all the mail. And
I understand the argument, Mr. Wright, to be slightly different. That is that one of the reasons for doing this conduct is because it oftentimes is unclear how to determine whether or not the mail has any contraband or any type of illicit drugs.
well, Your Honor, what I would say to that is their argument. However, if you look at another one of their arguments is they said since they've done this, the legal mail has been bringing in through the illegal mail. Well, they're stopping the legal mail. You know, they're claiming that we're getting it's coming in, we're catching it, we're stopping it. Now we're using barcodes, we're doing all sorts of things. But again, they have a duty or an obligation to us to protect our rights as well as serve their security. A blanket photocopying doesn't serve our rights, it serves their security measures above and beyond what they should be doing. Now, what I'd like to go, I got like 5 minutes left. What I'd like to say to Your Honor again is there's a due process issue involved in this, which is the regulation builds due process in from Procuna versus Martinez from 1974 that says if you make any piece of my mail contraband, you seize it, you have to give me a written notification, the person that sent it written notification, and give us 7 days in order to appeal it. They eliminated that as well. We don't get nothing. They just take our mail. We'll hold it for 30 days. If after 30 days you don't send it out at your expense, we're shredding your mail. So the due process is going from there. Again, you have a regulation that's giving us First Amendment rights, 14th Amendment rights due process, and they're just eliminating. They're saying we're not abiding by it. We also, as you know, I raised the Fourth Amendment argument. And that Fourth Amendment argument was based on the fact that the Department of Corrections has argued and won several cases within this court that their officers are law enforcement officers. Now, you have a regulation that tells them only in certain circumstances can they seize our mail. They're now seizing it with a broad stroke, all the mail across the board. Now, as law enforcement officers, under the Fourth Amendment, if you believe something's wrong with my mail, since you're a law enforcement officer and you're not abiding by your regulations, you need to get a warrant to seize my mail. That's what I'm claiming. And I'm stating this because under the Fourth Amendment, they're going to go with Hudson versus Palmer, which in that case, the Supreme Court ruled inmates doesn't have a right under the Fourth Amendment to searches inside their cell. And that case is specifically to cell searches. It didn't go in a broad stroke and move over to our mail. Our mail is protected again under the First Amendment. And we do have rights to get our mail. And they don't have a right to seize the mail unless there's something wrong with it.
So, Mr. Wright, are you saying that the 103 CMR 481 is unconstitutional on its face?
No, that's not what I'm arguing. They're not even abiding by 481, period. They're leaving that regulation alone. They're stepping outside the regulation and they're just making a broad stroke. We're doing this, and this. We don't care what the regulation says. I'm not challenging the regulation on this constitutionality because I think it is constitutional. I think it sets parameters for them constitutionally under the First Amendment, under the Fourth Amendment, under the 14th Amendment. I think it sets a duty to them, things that they must do, and they're just failing to do them because they're just making up that under security, we're going to take a broad stroke and we're going to wipe it all out. And Your Honors, and as I said, I think you noticed in my briefs, I argued to you that the photocopying machine photocopies and it allows them to maintain our mail inside the hard drive of the photocopy, which allows them access to it and to do anything else they want with it. There's no regulations forbidding them from selling it or distributing it to any other law enforcement officer, what they seize from us through that photocopier. And with that, I would quickly move on since I have 2 minutes, is again, we have a problem with the discovery. They wouldn't turn over the discovery, even though ordered to by the judge. As to the materials they use to make these determinations as to the drugs coming in. They gave up interrogatories, which they refused to sign. As you see, there's no signature on them. And by law and by mass rules of civil procedures, they must be signed by the person who makes those interrogatories. So we have a serious problem. And as I brought that to the judge's attention, he didn't address it. They didn't address it. And here we are. Is there anything else that you would like to ask me?
I'm going to inquire of the panel, Mr. Wright, and see if anyone does. And I see from both my co-panelists that no one has any further questions. You don't have to use all of your time. You have a minute left, but is there anything else that you'd like to say to us? Now's your opportunity.
Well, what I would say to the court is you have to remember that the excuse of the mail, of seizing our mail and being because of drug related as a problem within our mail system, that did not come up until after I filed the lawsuit. If you look at their paperwork prior to me filing the lawsuit, there was no mention of the inmate mail having a problem with it or that they needed a security measure for our mail. Only after I filed the lawsuit did they bring that up. And there's a case that came out of this court. It's a summary decision on the MAC Rule 23-0, which is Smith versus Wheatley, 99 Mass Appeals Court 1128. And it cites a United States Supreme Court case that says, they shouldn't be allowed to bring these arguments or argue these cases if it wasn't in their reasoning when they first started out. So that's been for that. And I appreciate you listening to me. Take the time to hear me out.
Thank you very much for your argument. We'll turn now to Attorney Handler, and you may begin your argument.
Yes, Your Honors. First of all, this case is a case about an allegation of a violation of constitutional rights. This is not about an allegation of a violation of the regulation. That, in fact, was the previous case that Mr. Wright brought for declaratory and injunctive relief, where Judge Squires-Lee indicated that the department had not complied with the APA in bringing the standard operating procedure and required the department to proceed to public hearing and promulgate a new regulation, which the department has done. This case is about the issue of the 2018 Standard Operating Procedure 2103 CMR 481, which was in place and is no longer in place. So it's a discrete period of time. The allegation of a violation of constitutional rights, the department would like to begin by saying there has been no case, federal or state, that the department is aware of which has indicated photocopying non-privileged, and this is only non-privileged, incarcerated individual mail is violative of any incarcerated individual's First, 14th, or Fourth Amendment rights. In fact,
I'm sorry to interrupt. You're speaking to the qualified immunity clearly established right issue. Is that correct? At least in part.
In part, but in part, I'm beginning to address his allegations to begin with as to whether there was a protected right.
Why don't you continue, and then we'll get to the qualified immunity question I have.
And with regard to whether there was a protected right, the department would say that, in fact, the proper analysis in this case is, in the first instance, is there a violation? And if there is a violation, is that violation permissible as a matter of law under the Turner standard? Because because it is reasonably related to a rational, legitimate penological interest and applying Turner. With regard to the First Amendment right, the lower court in this case was very clear that there is no core censorship. There is no violation of the First Amendment right to freedom of, to a First Amendment right to express one's thoughts. Mr. Wright had relied on the Pecuniar case, which indicates that once the letter is read, that in fact, the First Amendment right is satisfied. Mr. Wright attempted in the lower court hearing to address some that touch the smell of the letter, that there might be something else. which he, I believe now is verbalizing as a freedom of expression. I would suggest that the lower court did address that in the analysis where the lower court said, even if this court were to find that the First Amendment was infringed upon, the infringement is permissible. And that is because there is a legitimate penological interest in preventing the flow of drugs. I would suggest to your honors, even just yesterday, there was an article in the Boston Herald, of which you could take judicial notice, talking about the dangers of drugs in the Massachusetts prison system. There are facts you can take judicial notice of, that there was some introduction of drugs. The department and your honor has indicated that there may be different ways that the illicit substances enter the department, but total success of one way is not required if it is effective in some manner in reducing the overall flow. Applying the four-parts Turner standard to the First Amendment analysis and to all the allegations, the department would say there is unquestionably a legitimate interest in preventing the flow of drugs for the safety and security of incarcerated individuals as well as staff. Plaintiff, in this case, as well as all incarcerated individuals, have an alternative means of expressing their right to both freedom of speech and freedom of expression. The SOP required that the entire content of the mail that's not otherwise contraband be provided. Therefore, there is no censorship involved. With regard to the expression, the photocopying.
Can I ask you about the censorship issue?
Sure.
Are you trying to suggest, and I'm going to use one of the examples of pictures drawn by children. Are you suggesting that a copy of pictures drawn by an inmate's children is the same as the picture itself?
No, Your Honor. The department recognizes, and the lower court said that there may be some different sentiment that attaches to it, but the content is the same, but the fact that there is a sentiment that attaches to it does not rise to a constitutional violation when examined under the Turner standard. The department required under the photocopying SOP and under the current regulation that color copies be provided of those pictures. There is evidence in the record that with regard to color copies, this court has previously indicated that glitter is a problem because drugs can be concealed in it. Though there is the case Larkin out of New Hampshire, where the crayon drawings can conceal Suboxone and other types of drugs. The actual photocopies are sufficient to convey the sentiment, and the law is quite clear that while incarcerated individuals do retain their constitutional rights, they may be diminished by the fact of their incarceration, and that there are safety and security concerns that must be weighed against them. It's a balancing test. Is it
Counselor, I just want to ask you one question to be sure. You're not saying that a photocopy is the equivalent of a picture, for example, as Justice D'Angelo is pointing out, that's drawn by a young child to a parent who's incarcerated. You're just saying it's sufficient. You're not saying it's the equivalent.
It is sufficient. It is sufficient.
But it's not the equivalent.
It cannot be the equivalent, and the department cannot suggest that it's exactly the same. But with regard to the constitutional right of freedom of expression, it is an alternative means that the incarcerated individual has of expressing of that freedom of expression. They are not getting a black and white photocopy of something that their child drew. In the same manner, there are other rights curtailed. They cannot hug everybody that walks into a visiting room. There are safety and security concerns associated with incarceration that must be weighed. And the question is, are there alternative means? If you have a pop-up picture that a child draws, that must be taken apart entirely and looked inside to make sure nothing is concealed in it. If your honors review the affidavit of Patrick DiPaolo, he indicates that there is a large volume of non-privileged mail that comes into the facilities, and based upon new techniques to conceal drugs on paper, a quick visual inspection would not permit staff members to identify each and every suspect piece of mail. I would suggest that, excuse me, Your Honor. The SOP also allows for pictures to be sent in from verifiable third-party printing companies to be sent directly to the incarcerated individual, so they can receive actual photographs. Photographs that come in are printed in color. Those, I would suggest, are identical and equivalent to a photograph that is sent in. A color photocopy is equivalent to a color picture. With regard to the Overton case, I would suggest to your honors, indicates that the alternatives provided need not be ideal, they just must be available. The ripple effect of harm is quite clear, that drugs in prisons are a security issue, and there is no single way that the department can stop these drugs from coming in. The record is clear, as Mr. Wright has referred to, the letters from and memos from former Commissioner Turco, that there's additional canines, there's scanning, has been clear bag requirements. The department has taken number of measures and continues to this day to develop new measures. This is something that across the country, the case law has shown other states are battling with the same thing.
Let me interrupt. Let me ask you this. One of the things I heard Mr. Wright saying is that the regulations were not that effective. That's most of the drugs are not coming into the facilities through the mail. They're coming in through other ways. Is that something that we need to address with respect to the posture of this case now, or not? And if we do, what do you say about that?
You may address it, because I would suggest that the data was collected, this to Mr. Wright's exaggerated response argument. The data that is in the June 5th, 2017 memo was before the department took the steps to photocopy, and the department had that evidence as a need to photocopy. That is why in 2017, the department went to public hearing and changed its regulation to allow for photocopying, because it did not previously allow it. In the 3232 case in which Mr. Wright was a plaintiff, the issue was that the regulation was allowed to, was amended to allow, if there was color paper texture or a problem, an individual piece of mail could be photocopied. And the department, based upon the regulation, determined that all mail at a particular facility was in fact suspect. As if you review the affidavit of Mr. DiPaolo, he indicated that if you only targeted individuals that had a drug history, those individuals would basically intimidate straw individuals to accept their mail, knowing their mail would not be photocopied. In addition, because of the volume at facilities, it would be impossible for staff resources to visually inspect every single piece of mail as diligently as needed to be done. The data also shows that immediately upon the implementation of the 2018 SOP, the drug fines went down, but the fines in legal mail went up. And that is because, as the data shows, once people knew that their non-privileged mail was going to be photocopied, they started creating legal mail that was, the department would say it is fake legal mail. It is not the attorneys that were sending it in. It was people saying, well, if I just put a return of address of an attorney, I can send in a fake legal letter. That's not going to be photocopied, and that will come through. So the data, if your honors wish to review it, is supportive of the fact that there was a need. But again, as the lower court indicated, total success is not necessary. In this case, there is absolutely a safety and security issue. And I would suggest that there is no question that there is no violation of the First Amendment after a Turner analysis is done. Similarly, incarcerated individuals have no Fourth Amendment reasonable expectation of privacy. That's a non-issue. And with regard to the 14th Amendment, there's a plethora of cases, including one recent from this appeals court. Scanda is the case, was a Rule 23 decision where it found that there was no due process violation when an incarcerated individual had a right to send out, and in this case, it was a crayon drawing that had been found to be contraband. That also the Williams v. Meese case. I'm happy to address any further questions your honors have regarding qualified immunity, but essentially would rest on my brief that this is really a Turner analysis, and there is a string cite of cases in the brief where more restrictive case photocopying policies have been found to be not in violation of any federal right. So there is no federal violation, and even if federal constitutional violation, and even if your honors find a federal infringement, there is, under the Turner analysis, a rational relation to a legitimate penological objective.
Okay. I'm just going to quickly follow up to see if Justice Nyman had any additional questions about qualified immunity, and I see that he's satisfied with he doesn't have any further questions. Justice D'Angelo, any further questions on your behalf? All right, so I don't have any questions either. I want to thank you both very much for your arguments today. They were very helpful, very illuminating. We'll take the case under advisement, and we'll hope to get a response back to you as soon as we can. Thank you.
Thank you,
Thank you. Thank you, Your Honors.
Do I remain? Do I go out?
Unfortunately, we've somewhat forgotten about the Zoom etiquette, haven't we? Since we've been able to be in the courtroom more often. But our clerk will join us shortly, and what she'll do is check the waiting room for the other people to see if they're available. And I suspect that she will put you in the waiting room while she does that. Am I right?
Good morning. Yes, we can begin the next oral argument. Everyone has arrived. So when you're ready.
All right, so then you can just stay on.
Okay.
Morning, Mr. Gaskins. Just hold on with us for one moment while we double check and make sure that we're ready to proceed, okay?
Thank you.
Hey, everyone be patient. I think we're almost there.
Okay.
Good morning.
Good morning, everyone. Morning.
Good morning. Good morning.
All right.
Good morning. If everyone can just be patient, we're waiting for one more person to join us, and then we'll start the proceedings.
Okay, thank you.
You're welcome.
You said shiny, did it?
Got that thing on the screen right there. I don't know what the hell that is. This thing right here, blocking the screen. There you go. 'Cause I need to see.
Again, we seem to be waiting for one more person, so we're just going to hold on for a little bit.
Okay.
I believe all parties are here. We just don't have Mr. Brito's camera on.
Do we know the status, Catherine and Mr. Brito, if he's on, if he can hear us, if he's connected to us in any way?
See. We have sent over a message.
I think I heard you say that you were trying to send him a message.
Yes, I just sent him a
Okay.
message, but I haven't received anything just yet.
Well, to everybody, it's always just a little bit exasperating to get everybody on Zoom. We appreciate that. Let's just give it just another under a minute to see if we can contact Mr. Brito and have him on. And if not, then we'll proceed.
Okay, Your Honor. Thank you.
Okay, I don't want to lose anybody else for our argument, so I think it's time for us to go ahead and start. If everyone could just hold on a minute, I'm going to call the case and introduce the panel, etc. But first, let me check and make sure that we are being recorded, and I see that we are. All right. This is case number 2022-0185, Tony Gaskins and others
Thank you.
versus Thomas Turco III and another. The panel hearing this case today consists of Justice Eric Nyman and Justice Andrew D'Angelo and myself. My name is Ariane Buno. So a couple of things before we start. The plaintiffs here have 15 minutes to present their argument. And what we don't know as of yet is to whether or not you, Mr. Gaskins, are going to be the sole person representing the arguments on behalf of everybody in this case. Is that the agreement?
Yes, ma'am.
Yes.
Yes, ma'am.
Okay, that's great. So Mr. Hunter and Mr. Rice and Mr. Carter, you're here and you're gonna listen in, but Mr. Gaskins is going to present the argument.
Correct.
Yes.
And I'm gonna say for the record for Mr. Brito, who is not actually on right now, I hope he can join us, but this will be recorded and he will be able to, of course, listen to it at a later point in time. All right?
Yeah.
So Mr. Gaskins, I'm only gonna say that you have 15 minutes to present your argument. The judges here may intervene and ask you some questions because we've read the record and we've read your memorandum of law in lieu of brief, and we may want some clarifications. So don't take that as us being rude. We just want to have some answers to certain questions. And after you're done in 15 minutes, there's going to be a, excuse me, for talking too quickly, but there's going to be a timer in the left-hand corner of your screen. It'll start at 15 minutes. It'll go down. I'll remind you when you get close to your time. And when you're finished, Attorney Handler will argue for the department. Okay?
Okay,
All right. Thank you. So the timer can go on and you can begin your argument.
okay. Well, I want to start off by saying the Constitution is not the same, or at least it's supposed to. So what I would like to do first is open this as start a quote from Justice Holmes out of concurring opinion by Justice Marshall and Brennan in Peculiar versus Martinez, where Justice Holmes quoted, "The use of the mails is almost as much part of free speech as the right to use our tongues." That's a very, very important narrative right there, because that's what's going on here. Because we're in prison, doesn't separate us from the protections of the Constitution. But even more so, it doesn't allow the Department of Correction to impose their own personal standards upon the citizenry as well. Whereas the citizen has the most important aspect here of making sure that the mail that they send into this institution is received in its proper form as it was sent from the outside onto the inside. And so the only aspect of any type of government intervention has to be from what they call a reasonable suspicion, but it has to be on a personal case-by-case type of scenario. That matter was pointed out in Blackburn versus Snow. Whereas in that particular case, the sheriff tried to implement a policy of a blanket ban of strip searching and cavity searching every single prison visitor that came into the facility. The court said you can't do that. And in doing so, the court was pretty clear on the reason why that was not necessary. What the court said is that, and I'll go from just a little area where it is. In our view, the Blackburn court said in the First Circuit, is that this case poses a challenge that's difficult in many in this area. For we conclude that a rule requiring all prison visitors to submit to a body cavity search without any predicate requirement of individualized suspicion or showing a special and highly unusual institutional need cannot satisfy the Fourth Amendment. So the first thing that we're going to address in this, and this is looking at it from the Fourth Amendment perspective, not just only from the 14th Amendment perspective, because they addressed it not from the First Amendment or the 14th Amendment, they looked at it from the Fourth Amendment and came to their conclusion, rationalizing that the First Amendment in that particular case didn't have to be addressed because they felt it was a Fourth Amendment violation. So what we're going to do at this point is deal with the Fourth Amendment violation. So what happened here is when the mail comes into the institution, the regulation, which is supposed to have the force of law, says that they got a right to inspect or fluoroscope the mail coming in. That's their way of detecting any type of so-called contraband that might come try to enter this facility. But the intrusion can't be so far unless you can prove other narratives in order for the intrusion to be greater. So the Fourth Amendment protection comes in a couple of spheres. There's two perspectives behind this. So the first perspective was addressing Blackburn versus Snow. And what they said in Blackburn was, okay, they established that the fundamental purpose of the 14th Amendment prohibited unreasonable searches and seizures. It's safe to safeguard the privacy and security of individuals against arbitrary invasion by the government. That's what that says. As far as law enforcement in the Fourth Amendment, it says as such, although most commonly invoked in the law enforcement setting, the protections of the amendment apply fully to all forms of government action. All forms. So long as the person invoking the Fourth Amendment protection claim a justifiable or reasonable or legitimate expectation of privacy. So what we're looking at here is where there might be two aspects of this. So we can look at it from the Blackburn perspective, but we can also look at it from this perspective of law enforcement as is, what they have their limitations and restrictions on dealing with a private citizen. So if we look at it from the Blackburn perspective, that means this is a government action where they're imposing on the right of privacy from the citizen that's sending the mail. So what they did here was say, okay, we can just do this from our own personal perspective and standards, which the court said very clearly, even in Champaign, that officials are not free to impose their own standards. And that's Champaign versus Commission of Correction. So, in looking at it from the Blackburn perspective, we can carry it over to a law enforcement perspective. So let's say DOC personnel, our law enforcement, because this court deemed it so under Gunther versus Superintendent O'Connell, by applying the 258 Section 10D standard to give the exemption. So it's almost like a judge-made rule, but in the same token, it followed the federal court dealing with the FTCA. So they used MTCA and said that because we're following the guidelines and the model of the FTCA out of the federal provision, which is model 72 out of MTCA, we're deeming correctional officers law enforcement. So if you're using that term in and of itself as it is, then there's certain restrictions that law enforcement can't just impose on a private citizen. So we're talking about private citizen. So the private citizen sending mail in. So if law enforcement has any type of reasonable suspicion of them sending something in, then they gotta have what they call probable cause to even inspect whatever the contents they accuse them of having some suspicion.
Mr. Gaskins, I have a quick question for you.
Yes, Your Honor.
Are you challenging the constitutionality of the regulation itself, 481.12, or are you challenging the manner in which it's being applied?
I'm challenging it in both perspectives because the regulations have the mandatory predicates in and of itself, which limits the DOC's ability of how they go about taking this mail. Because what the DOC did with this mail, they said, okay, we're only targeting a certain segment of the population. So we're not targeting the entire Department of Corrections, where the regulations apply to the whole entire Department of Corrections. They said we're going to narrow it down to medium facilities of males and the maximum security facilities of males. That's it. We're not concerned about the males. So what they took that was they put an umbrella approach on it from their own personal standard, not from what the law allows or anything, which the Constitution is supposed to protect. Is that well, we're just saying everybody's suspicious. They admitted that in court when we was in lower court. They're saying they're assuming that everybody is doing something wrong, so we're just taking everybody stuff. And so what the Champaign court, no, what the right court, excuse me, the right court using County versus Commissioner said that you cannot just skip the inspection problem. Because that's
What I hear you saying, am I correct, Mr. Gaskins? What I hear you saying is that the regulation itself is just too broad. Is that your point?
It's vague on the standard because it doesn't give any type of clear point of the right of what they're doing right now. It's more, okay, well, if the commissioner, feels that this is going on, he or she got the right to just restrict this mail on everybody. Now, there's a due process aspect of this that's missing from this whole thing now. The due process is the most important thing of this. Okay, is the first right of notice. So what they say in due process is that if this mail has some suspicion to it and they want to seize it, first of all, they got to notify me that this is considered contraband for whatever reason it is. They got to notify the sender. Why they're doing is to give the sender at least some ability to object and protest the contents being seized and not being allowed into the facility. All right. That's one of the most important things that the courts all the way from the United States Supreme Court all the way down says that has to be a thing. What they do.
Can you tell me, Mr. Gaskins, is there a case, can you explain to me your position that the sender still has that kind of rights with respect to what leaves his or her possession and it's sent to somebody who's in a correctional facility?
Because what the things talk about is the due process. So the due process, this is one of the aspects of it. It says it requires that an inmate be notified of the rejection of a letter written by or addressed to him, that the author of that letter be given a responsible opportunity to protest that decision, and that complaints be referred to a prison official other than the person who originally disapproved the correspondence. What the court said, and this is not a peculiar, these requirements do not appear to be unduly burdensome, nor do appellants so contend, because they couldn't, because what they did, these protections and safeguards was placed in the regulation for a reason. It was placed there saying, okay, on a case by case, not just saying, okay, well, we got one guy, so we're going to punish everybody, and we're going to refuse everybody. So I brought this as a point of emphasis. This is a letter, this is a card, and this is a picture of my stepdaughter at the prom. So the sentimental value of the contents that you receive is different. So this card was sent from a lawyer who, an officer allowed me to have it, even though he said he was supposed to photocopy. So this had more value to it coming in this original form to me, that the lawyer sent and expected me to get in this original form. But the officer did not copy it, although he was required to, under the blanket ban policy. This is a picture of my stepdaughter and her two friends at their prom that I paid for. So the sentimental value of this is different from how I would have received it in the now, right? On the back of it, it states Chandra's prom. It states who are the people standing next to her. So I would have never known that. There would have been no value to receive this because I wouldn't have known who was standing next to my stepdaughter and taking this picture. So the sentimental aspect of this is based on when my stepdaughter sent me this, she expected me to have some attachment to what she had been through that I paid for on the prom, and who her friends are that's participating in the Photoshop, so her stepfather could see. All right, so this is what's taken from us, because what would happen if she sent this directly to me, they were photocopies, and the value would be way, way less, and have no sentiment whatsoever behind it. As for the card that I received from this past Christmas in 2023 from Attorney Captain Warren, this wouldn't have no value to it if it came to me in a photocopy form. So these are the things that has to be understood, and that's what the community is saying that you're protected from. And why they say that is this. The reason why they made the statement is because of this, you know. They said that both parties to the correspondence have an interest in securing that result, and censorship of the communication between them necessarily impinges on the interests of each. Interest here is that I received what she sent me in its original form to have a connectedness to me and her, as well as the attorney sending me this, and she wanted me to receive this in her original form, not an altered version, because that's what a photocopy is. So if my daughter or my girlfriend or my sister sends me something with their sin on it, I won't be able to have that intimate connection with it because they give me a photocopy version. Although when she sent it, she wanted me to have that connectedness with the sin of the other. It's no different from how an animal was able to be able, like if you got a dog can tell who her pups are from the scent of that pup. If she didn't have the scent of the pup, she wouldn't know which one would be hers because they all look like. All right, so there's a connectedness. So that's the reason why Justice Holmes said that this is an imperative thing, and just as we use our tongues. And because it's that freely applied, is because the constitutional imperative behind it is that they want to be able to have you to have the ability to connect with whoever your communicator is. All right. So now let's look at it from this aspect. The blanket ban applies to specific groups of prisoners, which is all males in a medium or maximum security facility. They're saying, okay, well, we're targeting this particular group because, you know, we're assuming that guys might be threatened or there might be something going on and everybody's suspect. That's not how the law functions. That's not how the Constitution allows such a thing. And the courts ruled against that, saying that they cannot be allowed to put their own personal spin or prejudice on how this mail is to be received. The courts, there's plenty of cases that clearly support this, saying that we can't allow this, and that's what's happening here. So they're not doing it from a logical or reasonable perspective. They're doing it for personal prejudices and their own standard of what they want to apply. Because remember, inside the grievances that I point outside the pleadings, when I briefed this, they said it's not a policy, it's a directive. They clearly said that in all responses to everybody's grievances. So that says that it's coming from a personal perspective.
Can I interrupt you? Excuse me, sir, you have about a minute left.
Yeah.
And I do have a procedural question to ask you. Right.
Okay.
So this case has been litigated for a little while. In fact, there have been 2 motions for summary judgment. Both of that have been allowed and are before us. Is it your point of view that there is an appeal from both of those motions?
There's an appeal for both of them. In the briefs that's before you, in the memorandum Louisville brief, they're before the court on the substantive arguments that has been placed before this court to deal with the merits of the claim based on the rationale of how the mail is being photocopied. I say harassment. and against the law and against what the Constitution compels in this perspective. Just because I am incarcerated doesn't stop me from having these protections, as well as the citizenry. And the citizenry is the most important aspect of this when you look at it from Peculiar versus Martinez, is that they have the right for the stuff to come in. They're protected fully.
And I'm going to stop you there again because you actually are out of time. But before we sign off, I wanted to be sure that the other two judges on this panel don't have any additional questions for you.
Okay.
And I see they don't, and that's fine. Thank you very much for your argument. And we'll now turn and hear from Attorney Handler.
Thank you, Don.
Yes, Your Honor. I would like to begin with how you ended with the question to Mr. Gaskins, are there two appeals before this court? There is an extensive procedural history, and the department sought leave from this court to request a motion for relief from judgment in the lower court of the first summary judgment motion. So, in fact, the department believes that the first summary judgment motion was in fact vacated by the lower court, and that is in the record. Therefore, even though the appeals were consolidated, the only appeal before this court is the one from the second motion for summary judgment. And that is where the department would like to begin with. None of the plaintiffs, other than Mr. Gaskins, signed any notices of appeal or any briefs in the appeals court with regard to what is currently before this court. The plaintiffs, including Mr. Brito, did appear and were aware of the summary judgment motion in the lower court, but they did not sign a notice of appeal. They did not sign any entry of appeal. They did not sign a motion for memorandum in lieu of brief. They did not sign any status reports. And because under Rule 11, Mr. Gaskins cannot represent them, the department submits and had previously filed a motion to have the other plaintiffs dismissed from this action, which was denied with prejudice to raise it again in our brief, and we did. So I would rest on my brief with regard to that argument, but the department wants to be clear that it does not believe that any plaintiff other than Mr. Gaskins is appropriately before this court on the appeal of the substantive issues at this time.
Yep. I have no further questions on that point in your brief, and I don't see my panelists either. So why don't you proceed to the merits of the argument?
With regard to the merits of the argument, the department submits that this is a question regarding a standard operating procedure that is no longer in effect. The department promulgated a new regulation, actually twice, but the most recent one was November of 2022. So the standard operating procedure is no longer 2103 CMR 481 is no longer being used. The question before this court is whether the photocopying of incoming non-privileged, and this does not apply to privileged mail, violates the constitutional rights of any of the plaintiffs or of the plaintiff the department would submit in this matter. The department, in its brief, has argued, and I will now outline, that there is no constitutional violation with regard to the First, Fourth, or 14th Amendment rights. And if, in fact, this court were to find that there was some infringement upon those rights, the infringement would be permissible as a matter of law under the Turner v. Safley analysis, which indicates that if there is some infringement of a constitutional right, if it is rationally related to a legitimate penological interest, the individual has an alternative means of expressing that right. The impact of accommodating that right would have a ripple effect, and there is the department has explored reasonable alternatives, and there is no single alternative that would allow for expression of the right in the manner in which the plaintiff requests it.
Counsel, can I ask a question? It was raised slightly in Mr. Gaskin's brief, which is the issue of after it is photocopied. It's my understanding that the inmates have some amount of time to ask that the mail be mailed back to the sender at their own cost. Is that correct? Is that my understanding?
That is correct, Your Honor. And there is documentation attached to the SOP. There is a notice to inmate. There's a form that the incarcerated individual may fill out. I would suggest to Your Honor that as a matter of due process and property rights, directing Your Honors to the Williams v. Meese case, the Supreme Court has held that the process in terms of a property right of that actual piece of mail, possession is not the same as ownership. Yes, the individual in this case would own the piece of mail once it is sent to he, she, or they in the institution. But if process is provided for them to dispose of that mail, even if it is at the cost to the inmate, that process is appropriate and sufficient to satisfy the 14th Amendment. I would also point Your Honors to the recent case. It's a Rule 23 decision of Skanda, where the appeals court, the Massachusetts appeals court, specifically found that the sending out of the mail, even at the incarcerated individual's expense, was sufficient process and did not violate the 14th Amendment right to property. And that case involved a crayon drawing being sent out to someone else. Does that answer your question, Your Honor?
Yes.
Okay. With regard to Mr. Gaskins has raised various Fourth Amendment issues that I would like to address. With regard to the Fourth Amendment issues, the law is quite clear that incarcerated individuals do not have a reasonable expectation of privacy with regard to everything within the institution. The record depicts, and the lower court in this case found, that incarcerated individuals were on notice that their mail was going to be photocopied. Therefore, that they had their non-privileged mail, excuse me. Therefore, there was no reasonable expectation of privacy. I'm not entirely clear where Mr. Gaskins got the two items that he was holding up today. They are not in the record. I would suggest to Your Honors both of those items would be contraband within the department, in that the first is not a legal communication, it's a holiday card. But he has indicated that the officer indicated to him that it should have been photocopied, but he made an exception. Again, that's not a privileged legal correspondence, but he seems to have received it. With regard to the photograph that he has, Mr. Gaskins is entitled to receive original photographs if they come from a verifiable third-party printing company. He may not, however, under the SOP or under the current regulation, receive photographs sent directly in by a third party.
Counsel, I'm glad you raised that, because I don't understand that. Maybe I'm not technologically savvy. An original photograph goes to a family member, brings it to Printing Plus, let's say, assuming Printing Plus is a verifiable vendor. So Printing Plus can send the original photo, or they make a copy of it and send it to the inmate. Can you explain that?
They make a copy and send it to the inmate. It's much like an Amazon package, Your Honor. An incarcerated individual may receive a book from Barnes & Noble because it comes directly from the publisher and there is assurance that there is no contraband in there. However, many Amazon mailings come from third parties where you could go home and box something up and send it with an Amazon label as a third-party seller. The department then has no assurance that there is no contraband in that package. So,
but Printing Plus is just making a copy of another picture. The inmate's never getting the original photo. That's what I wanted to make clear.
Correct. And well, they are getting an original that it could be a photograph on photographic paper. That I know there's a company named Free Prints where we accept photographs. If you ordered from Vistaprint and Vistaprint sent directly to the institution, that would not be a problem. The problem with what Mr. Gaskins is holding is he indicates there's something written on the back. That should not have come in that that suggests that it was sent in by a third party, that a third party wrote on it. A third party could send him a letter saying, I'm sending you a photograph. In the photograph is my daughter, my son, your niece, and he would have the same way of knowing who was in that photograph. But again, it's difficult to speak to the evidence in his hand, but he should not be permitted. I could not enclose in a letter a picture to be sent to Mr. Gaskins that he would receive. He would receive a color photocopy of the picture that he would receive if it was enclosed in a letter. But if he wanted an actual photograph on photographic paper, he would need to have that sent through a third party directly to the institution.
But if the photo had two sides to it, like Mr. Gaskins is showing a picture and then on the back writing, he would get both sides, correct?
He would.
Oh,
He would get both sides. Again, this would be an alternative means of accommodating the right. And the SOP indicates that a color photograph is supposed to be printed in color and provided to him. Again, it is not exactly the same thing, but it is an alternative means, and the SOB is clear that with drawings, color is provided. With photographs that come in color, color is provided. The real question is a safety and security question, and the department definitively has a safety and security interest in preventing the incoming of illicit substances into department institutions.
is there any reasonableness requirement? I didn't notice that in your brief. There's no mention of reasonableness. And what I mean by that is if DOC finds that, and I'm talking very hypothetically based on what you've told me, but in 1 year, there were 5 pieces of mail that had drugs in it. And that is a concern, obviously, because there were 5 pieces of mail. Does that mean that DOC, because of those 5 pieces of mail out of the thousands of inmates at DOC, could implement a policy like that because there is some concern? Or does it have to be reasonable?
I would suggest that even 1 piece of mail is a concern because it could cause a death if there was an overdose. That being said, that is not why the department took the steps. We have provided the data in the form of the memo, the June 5th, 2017 memo, indicating that there were over 300 incidents of drugs in mail. And if you read both Mr. DiPaolo's affidavit and that memorandum, he indicates that these numbers are the mail that had illicit substances that were found. There is no way to calculate the number of illicit substances that were not found due to the sheer volume of mail that enters department facilities and staffing restraints to go through all of these documents to visually and the techniques that have improved to conceal drugs on paper, that it used to be quite obvious when something came in and it was stained. Now there might be something in the ink. There might be something hidden in the crayon drawings. If you get a handmade card, you have to peel apart the layers to see if something is there. Technology, and Your Honor, I'm not there either, is advancing beyond anything that the department can anticipate. And that is why the photocopying is so essential, because if the original does not come in, it does not need to be searched. And Mr. DiPaolo's affidavit lays out how many hundreds of letters of non-privileged mail the institutions receive on a daily basis. And with regard to the equal protection argument, again, that Mr. Gaskins has set forth, felons are not protected. They're not a protected class. So it is a reasonableness requirement. It is not strict scrutiny. And the department chose to tailor the SOP to particular institutions where it determined there was a higher risk of drug introduction, that being male higher security facilities. And he explained the reasons in his affidavit that in terms of that an individual, if they thought their mail was photocopying, would intimidate another individual to accept mail on their behalf because their mail would not be photocopied. And that is in fact the reason for the blanket ban, is that all mail is essentially, or the department determined, and it was reasonable, that all mail at these facilities that have such high rates of drug introduction are potentially suspect, and there is no way to adequately visually inspect all mail at those facilities.
I just heard you say that strict scrutiny does not apply, and then I think you said it's a reasonableness standard. Was that what you said?
It's a Turner standard, Your Honor. It's a balancing test with regard to a rational relation to a.
So it's a rational basis.
relation.
It's more akin to rational basis, not
Yes.
reasonableness. Thank
Correct.
you.
Yes, it is. Turner is the applicable standard. And I have nothing further unless Your Honors have any further questions for me.
I see none. I want to thank you both. I'm going to thank you, Attorney Handler and Mr. Gaskins, for your argument. I'm pleased that the rest of you could join us today and listen to the argument and be present. We're going to take the case under advisement and get a response to you as soon as we can. Right.
Thank you, Your Honor.
Thank you very much.
Thank you, appreciate you. CT, Mr. How you been, bro?
How y'all been? I
I'm
said,
good.